Hello, everyone, and welcome to the 10th educational series by Africa and the Moot, co-sponsored by our dear friends the Arbitration Channel. And a big welcome to everyone from the Africa and the Moot community, arbitration practitioners, advocates, vis mooties, friends, and anyone else who's joining this open stream. By way of very, very brief introduction, my name is Stephen Fleischer. I am one of the founders and co-directors of Africa and the Moot, and I have the privilege of co-moderating today's session, which I think is going to be incredibly pertinent to your Vis-Moot journey for all of the Vis-Mooties currently on the call. Now, before we begin the talk and we introduce our speaker, I want to just say two quick things. One briefly about Africa and the Moot, for those who might not know too much about us. And then secondly, just a brief bit about the housekeeping rules of this call. About Africa and the Moot, Africa and the Moot is a fairly new, nonprofit, completely volunteer-based organization that was founded primarily for one reason: to promote participation from sub-Saharan African universities in the Vis-Moot competition in Vienna. In the 31-year history of the Vis-Moot, participation rates in sub-Saharan Africa have been very, very low. 1% historically, and in many of those years, actually 0 schools were able to participate. Africa and the Moot is currently supporting 17 universities in sub-Saharan Africa. And last year, the very large majority of our schools were able to make it feet on the ground in Vienna, which is something we're incredibly proud of. As we have grown, so have some of our programs, including an educational series, which we're having right this moment, as well as something else, the only in-person pre-moot in sub-Saharan Africa located in Nairobi, Kenya, that Africa and the Moot hosts with its partners every single February. So that's just a brief bit about Africa and the Moot. Moving on to housekeeping before we introduce our speaker, this call will take roughly 45 minutes in substance. And for this particular call, we are welcoming questions at any time during the talk. So there is no need for you to hold on to your question and ask at the end. If you have a question that comes up in the middle of the call, please type it in that chat box immediately. And our speaker today is very, very happy to stop his presentation and answer your question directly as it may come up. So we encourage questions at any time. There's no need to use your microphone, no need to turn on your cameras. You just have to type in those questions in the comment box. So without further ado, I will pass it along to my colleague and friend, Hada, who will briefly introduce herself, and then who will have the pleasure of introducing our speaker today. So Hada, over to you.
Thank you, Stephen. Hello, everyone. It is my pleasure and honor today to present Professor Ronald Brand. Professor Brand is a professor of law at the University of Pittsburgh. He was the driving force behind the creation of the University of Pittsburgh Center for International Legal Education, CILE, and its LLM program for foreign law graduates and its SGD program. Professor Brand regularly teaches courses in international business transactions, international arbitration and litigation, and matters of private international law. He has taught in many countries around the globe, and his scholarship includes more than 20 books and more articles in major journals. Professor Brand was a member of the U.S. delegation to the Special Commissions and Diplomatic Conferences of the Hague Conference on Private International Law, that concluded the 2005 Convention on Choice of Court Agreements and the 2019 Hague Convention on the Recognition and Enforcement of Judgments in Civil and Commercial Matters, and now is the U.S. representative of the working group considering a convention on parallel proceedings. He regularly works with the Commercial Law Development Program, CLDP, a division of the U.S. Department of Commerce, to train students in more than 30 countries in North Africa, Middle East, the Balkans, and Asia for the Vis-Moot competition. And with that, Professor Brand, the floor is yours.
Professor Brand, sorry, you're still on mute.
Sorry about that. Thank you, and thank you, Stephen. And I want to express my thanks to everyone who's involved in Africa and the Moot. I think it's a wonderful program. We here at the Center for International Legal Education at the University of Pittsburgh have worked with some of those who helped develop some of the aspects of the program and look forward to seeing you at the Moot and at various pre-Moots. And so I think it's wonderful that efforts are being made to improve the participation by schools from Africa, and want to help be a part of that. I will say that please do send Frade your questions as the program goes forward today. Feel free as well to email me questions afterwards. My email is rbrand, just rbrand at pitt.edu. So with that, let's see if, okay. I hope you are now seeing my PowerPoint presentation. Rada, can you confirm that it's showing up okay?
Yes, it is. Perfect.
It is. Okay, thank you, Stephen. Okay, let's talk about legal writing. And I want to talk about goal-oriented legal writing. That requires that you think like a lawyer. Well, what does that mean? Well, you should start by asking yourself, why is each party writing its memorandum? What is the goal at the end of the process? Well, the goal is pretty clear. It's to get an arbitral award in favor of your client. But that means the starting point is thinking about what you want to have in that award, because it is the award that matters. So everything in the memorandum should be directed at that goal. That raises the question, how can you use the goal to best structure and write your memorandum? Well, you want to know what you want to achieve. And that means that as a lawyer, where you start requires that you first think about where you want to end up. And in your memorandum, there is a part of the memorandum that I often think is just thrown in without much thought by students in the Moot. And that is a part that really should be the starting point. You have to know the facts and law in order to write a good memorandum. But where do you start? You start with the request for relief. And I'd ask you to think about how you've drafted that request for the relief so far, because that's where you really ask the tribunal to put in the award what you want to have in the award. What results do you want? And I suggest that in this year's problem, it can be very helpful to break down exactly what each party wants the award to contain. And that does not mean you break it down in detail in the request for relief, but very simple statements of each point. And you all know that there are multiple points, two clear points on procedure, but in the substance, there really are multiple points that the tribunal has to decide upon. And if you just say for the respondent that you want an award that dismisses the claimant's claim, you've missed the opportunity to guide the tribunal and to persuade. Now, you know the facts, you know the law, you've spent a lot of time on that. And how do you write the memo then? Do you wait until you have done all of your research, or do you start drafts before that? No matter what you do, you should understand that there's no such thing as a good legal writer, period. There are only good legal rewriters. Any good legal document is written and rewritten and rewritten. And you are going through that process. You understand that to be the case already. Now, I think it can be useful to write as you research, and you will always be researching as you write. With the Moot process, your research never ends until that last argument in Vienna or Hong Kong. This allows you to work on both the research and writing at what I think are distinct and important levels. And I really want to set out those levels so that we think about steps in the process here. You have, at this point, completed all of those steps for the claimant's memo. You're working on the respondent's memo. And you may feel that you've completed all of the steps for the respondent's memo, but I think it's helpful to break down those steps so that you think about each one and you think about how that plays out in your memo. And so that you get far beyond the first level of writing and research to what I would consider the seventh level. So let's go through those levels. The first level began in October when you got the problem, understanding the facts on their face. And once you read the problem, you begin to organize the basic arguments for your client, which then helps you go to the second level. And that is understanding the primary legal instruments from which the laws governing the contractual relationship, including the arbitration agreement, arise. These are the instruments that you will include in your vis binder when you do oral argument. You know what they are on this problem. They're the New York Convention, the UNCITRAL model law, the ICC arbitration rules. They are the CISG, certain of the UNIDROIT principles, and other basic sets of rules. The third level then is where you really dig into the research after you understand the facts and you understand the primary legal instruments. You want to see if someone else has done the research for you. So you read good treatises, you read good articles, you do the research to find them and see who has written the best material on each of the issues you discuss and that you have to write about in your memorandum. But you begin at a high level. If you start by looking for the primary arguments, you may miss someone who's put it all together for you already and saved you a whole lot of time. That takes us to the fourth level. And here's where you have to take that initial research in the secondary authority and move to a detailed understanding of primary authority, because your memorandum should not simply cite secondary authority. You should rely most heavily on primary authority, on cases, on treaties, on statutes, on arbitration rules. Those are the primary authority tools. Now, you have to have a detailed understanding of the primary authority, which you get from reading good secondary authority. As you do this, you should begin to understand the strongest arguments for both the claimant and respondent and be able to predict and preempt your opponent's arguments. Now, at this stage, you're writing the respondent's memo. So you already have your own claimant's memo as well as a claimant's memo from another team that you're going to prepare to respond to in the respondent's memo. This takes us to the fifth level of analysis. And here's where we expand the analysis on each issue by reviewing the facts in detail. And this is a process you're always engaged in, going back and rereading. Not only do you have to be a good rewriter, you must be a good rereader, because the more you research, and you know this, the more you understand new things each time you reread the record. And what you want to do then is focus on defining what are the issues that will make the difference, not in your memo, but in your arbitral award, the award you want to get, because that's what you have to do with the memo. And I'm going to pause here for a moment and say something about the process of communication as lawyers. And it's a process I'm engaging in and you are engaging in now. And this is why I feel constricted, because all I can see is my PowerPoint slide on my screen. I can't see you. That restricts the communication that's really necessary for effective education. It also restricts the kind of communication that's necessary in an arbitration or in litigation. You know that what's important when you write the memo, what's important when you make your argument to the tribunal, is not what you want to say. It's not what you want to present in your 15 minutes of argument or your 35 pages of your memorandum. What's important is not what's in your head, it's what's in the head of the arbitrators. Because they write the award, and in the end, the only thing that matters is the award. So how do you, in writing the memo, deal with that? Well, you deal with it, as I've already suggested, by starting with your request for relief. How do you define what you want the arbitral award to say, the basic points that it must include, and then elaborate upon? You then move back to think about, well, how is it you present the facts and the law in your memorandum in order to get that resolved? Now, one of the disadvantages in written memorandum writing, as compared to oral argument, is that in oral argument, you are sitting with the tribunal. You can see them. You hope they will ask you questions, because that's what tells you where their thinking is. And that's where you can assist them in getting from where they are thinking to where you want them to be thinking. And even when they don't ask questions, you can watch body language and know how they are responding to your argument, so that you can try to get inside their heads. That's hard in a memorandum, but you must think about doing that. And you must think about, what is it? What is the argument that ultimately makes the difference and can win the case? Now, in the 31st vis moot, that really is purely substantive. Both parties simply want a substantive award. The claimant wants an award that says the respondent must make a new payment, but this time to the claimant. The respondent wants an award that says the respondent has not breached the contract, or if the respondent has breached, is fully excused and has to pay nothing. Now, in the end, for your clients, that's all that matters. But we know that for procedure, there's something more. And this is a well-written moot problem, so it requires that we go into the procedure and deal both with the multiple contract argument and the consolidation argument. And those are alternative arguments for the claimant, but the respondent must respond directly to both, because the claimant only has to win on one, the respondent has to win on both, and you should think about that. So let's move to the 6th level of analysis and research, which pairs with writing. And keep in mind again that as you go through each of these levels, you can be writing the memorandum. First level, you've read only the facts. You should draft an outline of the memorandum based on the facts. Second level, you've looked at the primary legal instruments. You should then expand that outline to include those. Third level, you've then, using your outline, helped identify the problems. You've gone to the secondary sources. You've got the big picture, and you add to your memorandum. But then you go to the primary source material and you fold that in so that you've demonstrated levels of depth of understanding in your memorandum. We still haven't gotten to the final level of depth of understanding, but let's talk about the sixth level of research and writing. And this is where you've looked at secondary sources, you've looked at the primary legal instruments, but you go back to the primary legal instruments and review them for completion and full textual context. Now, what do I mean by that? You know that the basic arguments for the claimant and respondent on the procedural matters are based on Articles 9 and 10 of the ICC rules. Article 9 deals with multiple contract claims. Article 10 deals with consolidation. But you cannot just use Article 9 and Article 10. You have to know the full structure of the entire set of the ICC rules. That means your research has to be done in context, and your writing of the memorandum has to be done in context, and your oral argument must demonstrate that you understand how Article 9 and Article 10 relate to all of the other articles, 6, 23, etc., in the ICC rules. You cannot just focus on one article. The same is true of the substantive argument in the 31st vis Moot problem. The CISG, you know that you have to focus on Article 77. You know that you have to focus on Article 80, but there's more you have to do before you get to those. You have to deal with whether the contract has been amended to provide for a different account in which to make the payment on behalf of the respondent. And so you have to deal with the provisions of the CISG that allow amendment. And you have to then deal with Article 77, but you need to start with what section is that in? And why is it in that section? The same with Article 80, it's in a different section. What's the heading to that section? Why is it there? How does it relate to the full structure of the CISG? You must explain that in your memorandum in a way that shows you have a complete understanding of the CISG in its entirety, not just of Article 77 and not just of Article 80. And as is the case every year, this requires that you deal with a key provision of the CISG, and that's Article 7, paragraph 2, that deals with the process of determining, of interpreting the CISG, and of moving beyond explicit interpretation of each provision if and when there is some kind of internal or external gap in the CISG. The CISG, as you know, is not a complete contract code. It's more limited. And so there has to be additional law that comes into play. And you have to understand when that occurs. So you have to understand the entire context of the CISG. We then get to the final level, the seventh level. And this, in the Moot, is, I think, the most important. Now, you can't get there without understanding and dealing with all of the other levels. But you can't win anything without dealing with the seventh level. That's going back to the law, back to the facts in depth, and understanding the policies behind each argument and why the argument you are making is the right argument to support the decision the tribunal should reach. So I'm going to come back to that and re-emphasize policy analysis, because if all you've done is thought about simple legal framework and structure, and not about the policy behind the rules, you cannot represent your client well. Now, quite often, and I think you will find it in this year's problem, you will have issues where one party has the good technical legal argument, but the other side has the policy argument, the fairness argument, the equity argument that says, look, a simple technical legal analysis is not going to lead us to a good result, and here's why. And here's the result you can get to consistent with the legal sources that exist, but which will result in adoption of better policy going forward. Keep in mind here that arbitrators are like judges in a common law system. And no matter how much we talk about privacy and confidentiality, you know that your work in putting memos together has been facilitated by reading prior decisions of arbitral tribunals. And arbitrators are like judges. They want other people to read and follow their analysis. That means they want to be the ones who state the policy that others follow. Your job here is to help them do that, help them be able to write an award that does that. Finally, the 8th level, and this is not the research and writing level, but this is the level that you just keep coming back to every week, as you should, reread the facts, reread the record, to find the nuance that matters, because the more you research, the more the facts will mean something different to you. The deeper you go in the legal analysis, the more you understand why certain facts matter that you may not have thought mattered on the first reading. Now, and I want to come back to much of that, but right now to say, look, a good memo requires a progressive analysis, okay? And you've got to go through each of these levels and ask yourself, have we, in writing our memo, done the job at each level of analysis? And here I want to focus on something that is unique to the Moot process. In real life, most cases are won or lost on the facts. In real life, for most cases, the law is clear. The parties are disputing what the facts are. And they'll come to the tribunal, and the tribunal will need to determine which view of the facts, which version of the facts is the right one, and then apply the law to that. Because as you know, two different people who see the same thing happen will have different views of what happened. And that's part of the difficulty of coming to decisions in legal cases. But it's where the work of the dispute lawyer, whether arbitration or litigation, becomes most important. Now, what is it that's different in a moot? And this is important to understand in writing your memo. In a moot, the most important arguments are going to be not about the facts, but about the law. Now, that doesn't mean you don't know the facts, because as I've already said, you have to understand the facts at multiple levels and at the greatest depth possible to know how it fits the nuance of the law. Moot problems are designed to have students work on the forefront of the development of the law. And the VIS Moot is the best in the world on that. I have not seen a better pedagogical tool for that than the VIS Moot. But this means that finding the law means a whole lot more than just reading the legal texts. You don't just read the code and apply it. You don't just read the treaty or the statute, the institutional rules, or the contract text and apply that. You must dig deeper. The problems in the vis moot are problems that the drafters are using you to help develop in the law. Each year, thousands of students write hundreds of memoranda on legal issues that, as you already know, are not well settled. But if the issues are not well settled, then how do you get your or your client's goal to be consistent with the award the arbitrators will write as a result of your memorandum and your oral argument? That's the issue here. And if you think about that, you're not going to find the answer easily in your research of texts, even text of cases and of commentary. Maybe in commentary, you're going to find it in your thoughts about policy. Because in a moot, by its nature, the problem you are dealing with is on the cutting edge of the law. That means that a whole lot of people who are incredibly smart and have spent a lot of time at it have already thought about this, but it hasn't been fully resolved. And so you have to think about either what's the best argument that has been made that supports your client's position, or what's the better policy argument that you can make that will lead the tribunal where you want them to go. Now, let's go down to some of the nitty-gritty. Organizing your argument, or at this point, you've already organized your argument. You've done drafts of the respondent's memo. You've completed the claimant's memo. All of this, though, plays into organizing your roadmap and your argument for oral argument as well. So this remains important. But you need to choose the best method for your client's argument. When you're writing the memo, I suggest that you have practice arguments as you construct the memo. Don't wait until you've written both of the memos to have your first practice oral argument. Now, why is that? Invariably, what we have found with our teams here at the University of Pittsburgh is that if we do that, in the first arguments, an arbitrator who hasn't been working with the team asks a question that is a very obvious question, very simple question, but hasn't been addressed because the team has buried itself so deeply in its understanding of the case and the law that it hasn't explained well a very simple point. So have that practice argument, see what simple points come up. Now, how do you structure your argument under each issue? And there are two basic structures you can use in the memo. One is what I call a cascading approach. And some arguments necessarily come before others. In this year's vis moot, the multiple contract argument comes before the consolidation argument, not just because that's the way it's in the procedural order, but because that's the way it naturally has to work. The claimant wants both contracts to be dealt with in the same arbitration, wants the second contract simply to be added. That's a multiple contract issue under Article 9 of the ICC rules. But the claimant can lose on that and then say, but okay, even if we don't get that, we can use Article 10 and we can initiate a second arbitration and then consolidate consistent with the ICC rules. So consolidation is an even if. It's an alternative argument. If claimant wins on multiple contract in one arbitration, it doesn't need the consolidation win. On the other hand, as you write the respondent's memo, It's not really a cascading approach for you. You've got to win on both. You've got to knock out both addition of the new claim to the current arbitration, as well as consolidation of two arbitrations on the two separate purchase order contracts. But what you'll see is that within each of those issues, you will have cascading approach too. And here's where doing an oral argument before you finish your memo, I think adds value again. Why is that? It's because of the order you want to be able to address issues in your oral argument, and they should be consistent with your memorandum. And what you want to be able to do in oral argument is push as hard on each issue as you can, but if the tribunal isn't with you, simply say, okay, it doesn't matter. Even if you don't buy that, we still win because I fall back to my next argument and it stands on its own. That's a cascading approach, and you want to set that up in your memorandum. The other basic approach I call a compounding approach. Sometimes there are multiple arguments that have relatively equal value, but each enhances all of the others. Now, quite often, this will happen when you have a specific issue and the law or the commentary, cases, commentary, usually not the text, but the commentary and the cases, will say, here's the test. There are 5 elements that we consider. And then you can just go down those 5 elements. And they're not in a cascading order because you have to deal with each of them. And your discussion of each enhances all of the others. But I do think it's important that you understand how you organized it. And then coming back, you need a clear indication of which type of argument you're making. If it's a cascading approach, make it clear that it's alternative arguments. I'm sure you did that in your claimant's memo. You said we should add the new claim under the second purchase order to this arbitration. But even if you don't adopt that approach, then we get to the same result by initiating a second arbitration on a second contract and consolidating under Article 10. Okay, so do you extend to additional claims, or do you consolidate for the claimant? It gets to the same place. For the respondent, you have to be able to knock out both. And so that's where you are in the memorandum. We go back. When you write, what does your client really want out of the hearing? Keep in mind that this arbitration has already been bifurcated. The tribunal has said, even if we're going to take on the second purchase order, we're not going to deal with the issues of nonconformity here. When we get to substance, we're only dealing with the non-payment question on the first of the 2 purchase orders. So in this arbitration, if it were real, the award that comes after this hearing will not end the matter unless the tribunal simply says, we're not going to deal with the second purchase order. So that's why the procedural matters are really important. That will not prevent filing another claim on the second purchase order. Okay. But this hearing will be won or lost for the claimant, at least in the eyes of your client, on the breach of contract claim. And the same is true for the respondent. But whatever the decision on extension to other claims or consolidation of arbitrations, the parties will have another shot at the second purchase order at some hearing. So here's the question, and this is going to be important in your oral argument and your allocation of time as well. How much of your memorandum do you spend on the procedural matters? And how much do you spend on the substantive matters? It should be relatively equal. And my guess is that it probably is for you. But if you have spent 25 of your 35 pages on procedure and 10 on substance, you need to go back and rethink what you're doing there. Now, a comment about what I would call thinking outside the box, and you've probably already seen this. This is something unique to moot problems as well. Stefan Kroll, Professor Kroll, and others who draft the problem with him like to play little games and see how closely you're paying attention to the world. And what you've already found out is that there's an embedded issue in this problem that leads to a case that leads back to the naming of the parties in this problem. The case before the Dutch court sitting in The Hague that dealt with US sanctions when Russia imposed martial law in Poland in the 1980s. That case works through the principles that allow, under public international law, a state to apply, to legislate, to control conduct outside of its own territory. And that's exactly what you have when you get to part of the substantive question dealing with the Equatoriana General Data Protection Law. And so don't be afraid to sit back and just think about the problem from different angles. And if you research the name censor in the law, you'll find there's a case that deals with questions in this problem. So let's kind of go back and try to put things together here. Your research, start with the principal legal texts, find the specific provisions of each legal text that apply to the problem, identify them, and this is how you should structure your memo. You should work down through these points and see that you've done each of these in each section of your memo. Find the secondary sources that do the research for you, that help you understand how others have dealt with that specific legal text and have gone beyond just the words. Then understand the relationship, not just of Article 9 and 10 of the ICC rules or Articles 77 and 80 of the CISG, but the entire document, so that you know how it all fits together and you can explain why your proposal for the application of the individual rules is consistent with the structure of the entire document. Consider the drafting history of the legal text being considered. That's something that you absolutely have to do with Articles 77 and 80 of the CISG on this year's problem. Find interpretations of each legal text by courts and arbitral tribunals and by commentators. Follow the footnotes to the primary source references. Don't quote the secondary source when you can quote the primary source for the result. And you find that by doing your research and following the footnotes. One of my professors in law school would stand up in front of class and say, the lawyer who doesn't read footnotes is the lawyer whose children will starve. That's true in your research. That's true in real life. Research the facts, the law, and the policy. Conclude each distinct portion of your argument with the policy that supports your desired outcome. This is a well-written moot problem. It won't be decided simply on the facts. It won't simply be decided on the text of the law. It will be decided by convincing the tribunal that your result is the best policy going forward, given the legal issues that are presented. Now we get a level deeper in the nitty-gritty, in the writing. Develop the headings as an effective abstract of your memorandum. When I get a memo like from the VIS Moot, first thing I do is look to the table of contents. And I ask myself, is there a convincing argument if I just read the table of contents, read the headings, and it should help convince me. It is advocacy, persuasive writing at work. Work through the subheadings carefully. Tell the story. This requires that the headings make reference to the facts and the law. State the law clearly on each issue in the headings, but then develop it in a logical order. Create a logical progression that raises each question, answers it, and transitions to the next question in a way that prepares you for your oral presentation. Know whether you are making cascading arguments or compounding arguments. Organization is half the memo. Your table of contents is, if I can open your memo and read the table of contents and say, that sounds persuasive, that's where I'm going to start reading the rest of the memo. If I look at the table of contents and it just has a set of, this is where we end up, the persuasive process has not yet begun, and I start reading the memo behind where I should be in terms of favoring your client. Move from the headings to topic sentence. Every first sentence of every paragraph, every topic sentence is its own heading. Write clear topic sentences and address only one issue per paragraph. Go back now and reread your draft of the respondent's memorandum by just reading the headings and reading the first sentence of each paragraph, and ask yourself, is this the process that fits together and preempts questions if this is the way I develop my oral argument? Move from topic sentences to clear analysis. And that's where you work in the authorities and demonstrate your depth of understanding of the work that's come through your research. Finally, include clear reference to the policy supporting your desired outcome in each section of the memorandum. Okay. One last effort here. Some very specific points on writing headings and topic sentences and every sentence in the memo. Use the active voice, not passive voice. Remember that intangible concepts or thoughts cannot act. The subject of your sentence should not be an intangible concept or thought. Use headings to persuade. This requires references to both facts and law in the headings. Paint persuasive pictures using your headings and topic sentences by incorporating facts and law. Use your topic sentences to develop the heading under which they occur. Don't push more than one idea into a single paragraph. Long paragraphs tend to move the reader away from where you want to be going. Finally, just a couple of examples, specific, since we can't talk to each other and have you suggest examples. When I talk about using active rather than passive voice, think about this. The fraud that induced respondents' payments was caused by the claimant. That's a passive voice. Not only that, but the fraud can't do anything. Where do you find the fraud? You don't. Compare that with this on the same issue. Claimant breached its obligation to notify respondent of the data breach and thereby caused the actions that led respondent to believe the contract had been amended to allow payments to a new account. Each of those headings can contain the same following material, but which one paints a picture that moves the reader toward your position in a better way? The second includes references to facts as well as concepts of the law, breach, data breach, and duty. Okay? Again, painting a persuasive picture. Compare these 2 points. This tribunal should not add the new claim to the pending arbitration. That's exactly the point you want to make, but is that the way you want to make it? Think about this. The tribunal should reject claimant's attempt to add the nonconformity claim under the A-1564 contract to the non-payment claim under the 9601 contract as inappropriate and inconsistent with the ICC rules. The second statement makes clear not only that you have 2 separate contracts, you have two totally different issues. One's nonconformity, the other's non-payment. And that leads you then to inconsistency with the legal requirements in the ICC rules. Use your headaches to paint pictures and to make reference to both law and facts. A reminder, where do you begin writing the memo? What's in your request for relief? In the end, three things will make the difference. Preparation. Those who do the better work, research, read the record more times, are going to be better prepared. Precision. Using language better in the memo. Write every sentence, go back and rewrite every sentence. Because the better preparation, the more the precision, the better the persuasion will be, and that will get you to the result you want in the arbitral award. I hope this has been helpful. I'm going to stop sharing my screen now. We haven't had questions come in, but I think we can allow some time for questions if there are any.
Thank you, Professor Brand. We actually do have one question that just came out. It reads, is there an art to using in the alternative arguments without discrediting your prior argument? Is there a risk of undermining yourself?
Yes, there is an art to that. Now, and let me speak specifically of this year's problem in demonstrating that. I don't think that art is difficult for the memorandum writer or the oral advocate when you're doing the cascading argument from Article 9 to Article 10 of the ICC rules. Okay, because when you say the claimant does that, the claimant says, well, we should have both claims in this arbitration. Or in the alternative, if you don't buy that, we should have both two separate arbitrations and then consolidate them and get to the same result. I don't think the second one does damage to the first one. But let me suggest where there is a potential for that. And that is Article 80 in the substantive argument. And Article 80 is in the section, only two articles, on exemption. And I refer to this concept as excuse for non-performance. Because Articles 79 and 80, keep in mind, apply only when there has been a breach. And so if you're responded, you've got this cascading argument. First, we didn't breach because we did pay. Okay? But then even if we did breach and should have paid to the other account, we are excused under Article 80. Now, can one do damage to the other there? At that stage, not necessarily. I think those are consistent arguments, okay? Because what you're saying under Article 80 is similar to what you said on we didn't breach. What we did was the claimant's fault. Okay, and that means we didn't breach because we did the right thing, because through apparent authority and amendment of the contract, we paid to the right place. Under Article 80, you're saying something different. You're saying, okay, even if the tribunal finds we did breach and we should have paid to the other account, now we go back to what the claimant did. And it may not have amended the contract to allow us to pay somewhere else, but it did satisfy the requirements of Article 80. You can make those, I think, without being inconsistent. And now I'll test the research here just a little bit, and at the risk of going one step too far as professor here. But I'll ask you to think about that. Is Article 80 all or nothing? Does Article 80 mean that either the respondent is totally excused or not at all? Or can respondent be excused in part? Can we apportion responsibility for the problem? Think about this. What's fair here? Did the claimant do what was reasonable? Yeah. Did the respondent do what was reasonable? Yes. Did the claimant make some mistakes? Absolutely. Did the respondent make some mistakes? Absolutely. Do we put the entire burden on one party or the other? That's what Article 780 seems to do. Can you, under Article 80, argue that maybe you split the burden? And if it does, that is a third cascade, or you cascade again to a third matter. And there you raise certain risk, because if you start to say, well, maybe we're only partly responsible, but what you really want is a decision that you're not responsible at all. And so, yes, there's absolutely an art to making that argument. It's a very good question, given this problem.
We do have a follow-up question to the first question. It reads, does that mean we have to draft the alternative argument, keeping in mind that it can be the only argument that the party can make?
But it can be the only argument. Well, in a memo, there's a difference between a memo and oral argument here, because oral argument, you want to think about how much time do I have and what do I have to leave out so I can use that time properly. In the memo, you have to think about how many pages do I have, but you want to make reference to all of the arguments so you don't leave anything out. And so, since we're talking about memo writing primarily here, you need to touch on all of the arguments, but focus on the ones that are strongest for getting the result for your client that you want in the award. Okay, and so with that question, I'm trying to think of specific issues here. I don't think you'll get the cascading approach where you say, well, we really only want to make the second argument the cascade, because you want to make your strongest argument first. But this is where that, I guess, changes a little bit, because the second argument may be the strongest in the cascade, but you want to try the first one. And sometimes, if you're using a cascading approach, you in fact are at an advantage if the weaker arguments are first, because in oral argument, if you get pushed on those, you can clearly fall back. If you make your strongest argument first and lose it, can you really fall back on the other arguments? So you have to think about using the cascading approach so that being pushed in oral argument and losing a point doesn't shut you off from going to the other argument. It allows you to lead naturally to the other argument in order to escape the one the tribunal is giving you trouble with.
We have 3 additional questions, starting with the first one. Should we always remember that as lawyers, we know, we do not think?
That we know what?
We know, we do not think. There was a question with a question mark.
No. The best lawyers are thoughtful lawyers. And the best oral arguments and the best written memos are not something that pounds on the tribunal, nor are they something that says, you have to do this and then the tribunal must do this. No, that's never going to help you persuade anybody. The idea that you know where they should be will more likely lose points than win points. And all of this leads up to oral argument. The best oral argument you can make is not a strident statement of your client's position. It's a thoughtful presentation of the difficult questions the tribunal has to address, as well as an offer of the proper outcome and a reasoned policy behind that proper outcome. Keep in mind that you're not here to pound the tribunal to win your case. You're here to help the tribunal solve a problem. So think about sitting down, having a cup of coffee, having a cup of tea, whatever you want to have in front of you, and working with somebody else to solve a problem together. Not saying, I have the solution, here it is.
And moving to the next question. Staying within page limit can be challenging when there is so much or so little to write about. What's the best way to strike a balance between your teammates and the issues?
There are two parts to that question. One is, how do you take a 50-page memo and make it 35 pages? The other is, how do you deal with your teammates to leave your part in and take their part out? And I'm going to deal with the first part, which you should do together. And I encourage our students to not worry about page limits when they write first drafts. Okay, put everything in there and then organize it and tighten it up. And this is part of precision and preparation, going back over, rewrite. This is the rewriting. Okay, a number of people are alleged to have said the same thing. One of them is Samuel Clemens, Mark Twain, an American author who wrote a letter to a friend and at the end said, "I'm sorry the letter is so long. I didn't have time to make it short." Your job in writing the memorandum is to take the long memorandum and have time and use the precision of language to make it short. We can always say in fewer words what we initially say in more words. That's the process of taking the longer memo and putting it in to the page constraints.
We have one additional question with regards to Article 80. On the Article 80, what if you're making two different claims from it? One is a cascading argument. The other one is an alternative argument. Is it possible?
Well, when I say cascading argument, they are alternative arguments. You move from one and drop over to the next. And that is an alternative. So even if you don't accept the argument I'm making now, here's one that wins the case anyway. And so now, but with Article 80, I think you have the possibility, given the commentary, to first make the argument that the respondent is completely excused based upon claimant's conduct, and then fall back and say, well, even if you don't completely excuse us, you have to excuse us at least in part. And that's a dangerous cascade. It's a dangerous alternative argument because you don't want the second result, you want the first result. That can be more effectively done in oral argument than in the written memorandum, because you can see how hard the tribunal is pushing you. You can read their body language, and you can see how reasonable it might be to fall back to the second of those positions. Having said that, again, I think you want to indicate that you understand each of those positions in the memorandum, and so you want to address them, but you don't necessarily want, but you have to do it carefully. I'll just say it that way.
Professor Brand, we have two final questions for you, and then we'll let you off the hook. Okay. One question that I've received, and we actually get quite a bit from our community, is how formal should our legal writing be? Is there such thing as being too formal, where a lot of our students in their various constituencies are used to writing in that kind of way? Or is there such thing as perhaps writing too casually? And how do you strike the balance between those two?
Yeah, I think you can harm yourself more by being too informal than you can by being too formal. So if you're going to err on the side of being formal. Now, I'm not sure in different cultures and legal traditions, what is formal in legal writing can be different. I think that when we're talking about a global type of audience, both common law and civil law, and here's where the same sentence, the same paragraph can have a different impact on two different readers. And you just have to be aware that that can happen. But I truly believe that precision results in simplicity of language, and that complexity of language makes persuasion more difficult. So if by formality one means complexity, I would avoid that. I would go for simplicity, precision, and persuasion.
Fantastic. And I think our very last question, I'll read it verbatim. Is there a place in the memorial to discuss what makes sense, even if that is not strictly grounded in the law?
Yes, and that's encompassed what I call as the policy argument. And if you read the text in a simple, what you at first think is a plain meaning, reading of that text leads you to only one place, but as an arbitrator, you just wouldn't feel comfortable with that result. That's when you get into the policy, and this is where, and quite often you have different dichotomies. One is technical legal argument and fair result. The other is efficiency and equity. And sometimes a certain approach can be simply much more efficient. You consume less time, it costs the parties less to get there, but in the end, it's just not equitable. And that's where you have to look at the balance and say that on balance, the policy says we go the direction that favors our client.
Fantastic. I think that's a very helpful answer to all of our students. Well, Professor Brand, we don't want to keep you any longer, and I think we want to very clearly conclude by saying thank you so much. This was not only an excellent talk, but it was such a relevant talk to all of the people that were listening. They are all in the thick of their second memo, and these are lessons they're going to take with them as they polish up their respondent memorial, but also in their future legal writing. I think this was an incredible talk, and we just can't thank you enough for taking the time to talk to our whole community.
Okay, well, thank you for having me, and thank you to all of the students for joining us. If you're going to be in Vienna instead of Hong Kong, let's see each other and have a chat.
Looking forward to it. Thank you so much, Professor. We'll keep in touch. Thank you.
Bye-bye.